Welcome back. This is The Law is My Oyster, and I'm Roxette W. Stedman, BL. In this video, we're going to be looking closely at the first segment of a witness's testimony, the examination in chief, what it is, how it works, its limits, and the special rules about leading questions and hostile witnesses. So, what is the purpose of the examination in chief? The examination in chief is conducted by or on behalf of the party who calls the witness. Its main purpose is to enter into evidence the relevant facts that supports that party's version of the facts in issue. Because this is essentially a friendly interrogation, the lawyer asking the questions is kept on a tight leash. How tight often depends on the attitude of the trial judge and perhaps the opposing lawyer, but as a rule, the examination in chief is regulated by two main constraints. 1. Questions must be designed to ensure relevant and admissible answers. 2. The examining party cannot ask leading questions of their own witness. The first restriction is actually applicable to all questions. They must always seek to introduce relevant and admissible evidence, friendly lawyer or not. Anything else is wasting the court's time. The second restraint is slightly more challenging. As a rule, it is simple enough. Leading questions are not allowed in examination in chief. But what is a leading question? A leading question is typically one that suggests the desired answer. An example, asking a witness, "Did that make you angry?" rather than, "How did that make you feel?" That example is straightforward. However, another type of leading question is more difficult to identify. That is the question that assumes facts that are in dispute. What that means is that the question will contain information that is not yet before the court, and that information is being contested by the parties to the dispute before the court. An example would be, "What did you do after the accused assaulted you?" where the assault has not yet been proven. This often comes down to the order of questions, but sometimes it is wise to refrain from giving things titles like assault and rather speak of the incident, even where the complainant has already testified under oath that they were attacked by the defendant. The practical difficulty here is that it is easy to analyze questions on paper and declare them leading or not. But in the heat of battle during a trial, the opportunity to say a question is leading either during or immediately after the question has been asked is not always clear-cut. If you do get away with a leading question, and this happens more often than people realize, that evidence is in and on the record, assuming it is relevant and admissible. If the jury are clever enough to catch the leading question, where the opposing lawyer, and perhaps the trial judge, did not, it is always open to them to attach reduced weight to the answer. As you might expect, this does not happen very often. The result is that despite this strict prohibition, leading questions do slip under the radar. The reason for the ban on leading questions is obvious. The witness must give their own version of what they saw or otherwise experienced in their own words. Your lawyer can keep you on the straight and narrow path of relevance, but they may not lead you by the nose. Your lawyer is even allowed to tell you the questions they will ask you, but they are not allowed to tell you how to answer those questions. If you are told how to answer a question, this is known as coaching and is highly unethical. It could result in severe professional sanctions against the lawyer who is doing the coaching, as well as destroying the credibility of the witness, thereby reducing the weight of their evidence. This helps prevent what is known as tailored testimony and promotes truthful, more balanced evidence rather than answers shaped to fit a party's case. There is some flexibility around the practice of leading questions. This is more of a practical solution than a purely legal exercise. The aim is to speed up proceedings. Leading questions may be permitted on introductory questions that set the scene rather than deal in contested facts, on facts not in dispute, The opposing lawyers will often meet before the trial and agree what issues and facts are in dispute and what issues and facts are not. Again, this speeds up the process. See, for example, Section 22 of the Criminal Justice Act 1984. To identify people already mentioned by another witness or objects that are already admitted into evidence. To help a forgetful witness remember, but this must be used with caution and is best only done after obtaining permission from the trial judge. The last exception is the one much loved by film and TV writers, when the witness is hostile. The rule against attacking your own witness. At common law, a party cannot cross-examine or attack the credibility of a witness they called. This would seem obvious, as trials would be chaotic if you were allowed to attack your own witness. In most cases in the courtroom, the term hostile witness is barely mentioned, despite what the TV might tell you. The reason is simple and, again, practical. If a witness turns bad, either by changing their answers or doing all they can to help the opposition, it is easier to get them off the stand as quickly as possible and call another witness to testify to those facts in question. However, if that witness is a key witness, meaning they are the only one who can testify to a particular and important fact, then it may be necessary to declare them hostile. This is the second major exception to the rule against leading questions. A party may cross-examine their own witness if the witness is declared hostile. The common law has been strengthened in criminal proceedings by Section 3 of the Criminal Procedure Act of 1865. Yes, you heard correctly, 1865. Section 3 permits a party, after obtaining permission from the trial judge in the absence of the jury, to contradict the witness or prove prior inconsistent statements, but only after identifying the circumstances of the statement to the witness and asking whether they made it. The trial judge decides whether a witness is hostile after an application by the calling party, which is made after the jury have been returned to the jury room, thereby avoiding their contamination. The trial judge has a lot of flexibility in deciding whether to grant the application and can ask to see notes or the statement itself, or any other evidence of a prior statement that conflicts with the witness's answers on the stand. If leave is granted, the jury will return and will soon know something big happened in their absence, because the lawyer will now be cross-examining his own witness. The interesting thing about this exercise is that once a witness is declared hostile by the judge, his own lawyer can ask any relevant question, not just on prior inconsistent statements. The witness cannot refuse to answer these questions, even though different answers to the same questions might lead to a charge of perjury. There is no privilege against self-incrimination in this scenario. However, the usual exceptions still apply. The witness cannot be questioned about bad character, misconduct, or convictions. In its decision, People v. Taylor, the Court of Criminal Appeal, set out the procedure. 1. Put to the witness that they made a materially different earlier statement. 2. If they deny it, call the person who recorded the statement to prove it exists, without revealing the contents yet. 3. Recall the witness and show them the statement. 4. Direct their attention to the contradictory passage. If the witness admits the contradiction, that may be enough. If they persist in denial, the proven statement becomes evidence that they made a contrary statement. Later authority clarified that cross-examination can aim to persuade the witness to stand by their original statement. What is very important to remember in these cases is that a prior inconsistent statement is only evidence of credibility, not of the facts stated. The jury must be told this. So persuading the witness to confirm it is often more useful than merely discrediting them. There are statutory exceptions to this rule, but these go beyond the limits of this video. But if a hostile witness confirms its contents during cross-examination, those contents become part of their evidence and may be relied upon. Even then, inconsistencies may reduce its weight, and judges may instruct juries to treat it cautiously. A witness's evidence does not have to be accepted as a whole or rejected entirely. That assessment is for the jury with proper judicial warnings. So, to summarize, examination in chief is about eliciting supportive evidence. Leading questions are generally prohibited, but have defined exceptions. Parties cannot attack their own witnesses unless they are declared hostile. The hostile witness doctrine allows cross-examination and use of prior inconsistent statements under structured rules. Understanding these principles is essential for grasping how oral evidence is controlled and tested in the criminal court. This is Rocksteady coming to you from beautiful Waterford. Stay safe and be kind to everybody, including yourself.